You're listening to Audiology. Support our work on Patreon and be sure to submit your requests for topics in the comments below. In a legal battle with Timothy L. O'Brien, the author of Trump Nation, Donald Trump, during his 2007 testimony, admitted that it's common practice for people to exaggerate the value of their properties, but insisted he didn't do so excessively. He explained that when it came to valuing properties, he would share his opinion with Alan Weisselberg, the chief financial officer of the Trump Organization, who had the final say and whose estimations Trump described as conservative. In one instance, Trump highlighted a property that jumped in value from $80 million in 2005 to $150 million the next year, attributing the increase simply to his belief that it was initially undervalued and that its worth had significantly appreciated. Between 2011 and 2015, the Trump Organization was reported by the Washington Post in November 2021 to have presented certain properties as being worth much more to potential lenders than they claimed to tax authorities, with discrepancies running into the millions of dollars and in one case over $500 million. Before Donald Trump took office as president in January 2017, his lawyer, Sherry Dillon, announced that the Trump Organization's business interests would be placed into a trust overseen by his sons, Donald Jr. and Eric, along with Weisselberg. The issue of asset valuation resurfaced in February 2019 when U.S. Representative Alexandria Ocasio-Cortez of New York inquired during a congressional hearing if Trump had ever inflated asset values to insurance companies. Trump's former personal lawyer, Michael Cohen, responded to Congress, affirming that Trump had indeed overvalued his organization's assets for purposes like making it onto the Forbes wealthiest individuals list, while undervaluing them to reduce real estate taxes. This testimony led to the New York State Department of Financial Services issuing a subpoena to Aon, the longtime insurance broker for the Trump Organization, following month, March 2019. In March 2019, New York Attorney General Letitia James, who had promised during her 2018 campaign to conduct such an investigation, began looking into the Trump Organization. By December 2019, her office had demanded records from the organization, which weren't provided for at least 21 months. On July 17, 2020, Alan Weisselberg gave testimony that was later proven false. He falsely claimed he hadn't been present during discussions about the size of Donald Trump's triplex and said he only became aware of a mistake on the 2016 financial statement after reading a Forbes article in May 2017. Weisselberg later admitted to lying about these statements and pled guilty to perjury nearly 4 years after the fact. In August 2020, Attorney General James revealed in a legal document that her office had been examining the Trump Organization for inflating asset values for 18 months. She sought a court order to make the organization and Eric Trump, who had avoided a subpoena and canceled an interview, cooperate with the investigation. In September, Judge Arthur Engoron required Eric Trump to give a deposition by October 7th. He complied on October 5th, choosing to invoke his Fifth Amendment right over 500 times to avoid self-incrimination. Then, on September 2, 2021, Judge Engoron demanded the Trump Organization explain their compliance with the subpoenas, some of which dated back to December 2019. They were given until October 15 to comply, or a third-party firm would be appointed to examine their records. On December 1, James subpoenaed Donald Trump as part of the civil case, intending to depose him on January 7, 2022, along with subpoenas for Ivanka and Donald Trump Jr. issued the same day. On December 20, 2021, Trump's lawyer, Alina Habba, sued James, claiming her case was politically motivated to harass and intimidate Trump. However, James argued that Trump was trying to avoid giving a deposition. In May 2022, Judge Brenda K. Sands dismissed Trump's lawsuit after a hearing, and Trump appealed in June. By August, Habba asked the appellate court to restart the lawsuit. Nevertheless, in January 2023, Trump's legal team withdrew their appeal, with Habba noting the withdrawal was for strategic reasons. On January 3, 2022, James and an attorney representing an organization submitted legal paperwork to a court, calling Ivanka and Donald Trump Jr. into the spotlight in a civil lawsuit. They also attempted to block subpoenas aimed at them, arguing that Attorney General James was bypassing due process to collect evidence for an associated criminal investigation. A legal specialist mentioned by the New York Times indicated that it is up to the Trump's legal team to prove this argument, Although they can refuse to speak to protect themselves against self-incrimination, their silence could be used against them in the civil case. James suggested that the Trumps were repetitively stalling to avoid being questioned under oath. On January 10th, in pursuit of halting the legal proceedings, Haba sought an injunction against James, echoing Trump's earlier lawsuit against the Attorney General. At a rally on January 15th, Trump highlighted James's harsh criticisms of him through a video, ending with "unhinged liberal" superimposed on James's face. In a subsequent rally, Trump targeted James and Fani Willis, the district attorney for Fulton County, Georgia, labeling them as biased prosecutors and hinting at mass protests they acted improperly. On January 31st, James's legal motion stated there was no pressing need for the injunction she was accused of seeking, emphasizing her focus on evidence rather than politics in her actions. By January 18th, James pushed for Trump and his eldest children to be summoned to court and to provide documents, revealing their investigation had found evidence of the Trump Organization's falsely inflated asset values for financial gains, including misleading the Internal Revenue Service. The investigation zoomed in on Trump's financial statements, which reportedly played a role in acquiring over $300 million in loans through exaggerated net worth claims. Out of over 5 million documents the company provided, Trump personally submitted only 3, with his signature on some, including his federal income tax details. The Attorney General's documents pointed out various discrepancies, like the overvaluation of Trump's Scotland golf course and his Trump Tower apartment, the latter being vastly overestimated in size and value compared to objective estimates. On February 1, 2022, Trump's legal team argued to dismiss the subpoenas, citing James's political animus and alleged bias, which they claimed violated constitutional and state protections. On February 9th, Mazars, the accountancy firm for Trump, withdrew its support for financial statements made from mid-2010 to mid-2020 after Attorney General James's findings questioned their validity. The Trump Organization suggested this decision nullified the ongoing investigations. Yet, even as Trump denied misleading financial practices, citing his brand's value as offsetting any discrepancies, James countered this, highlighting contradictions in Trump's defense. In these filings and legal maneuvers, the central theme revolves around efforts by both sides to navigate the complexities of legal accountability, financial transparency, and the interplay between political and judicial processes. On February 17, 2022, Judge Arthur Engoron decided in favor of Attorney General Letitia James' request for subpoenas against the Trump family, rejecting the argument by Trump's lawyer, Alina Habba, to pause the civil investigation during a separate criminal inquiry. Engoron noted that simply because Donald Trump and his children, Donald Jr. and Ivanka, weren't summoned before a jury by the Attorney General or District Attorney, it didn't mean they could skip testifying in the civil case. Although he clarified that if they chose not to answer questions to avoid self-incrimination, it wouldn't affect the criminal case. Trump's defense argued he would only testify before a criminal grand jury if it granted him immunity, emphasizing there's no indication the Trump children were specifically targeted by the criminal investigation. Habba accused James of bias and unethical conduct against Trump. In response, Engoron stated that even if James personally disliked Trump, it wasn't a form of illegal discrimination, pointing out that disliking someone for political reasons isn't the same as discrimination based on race, religion, or gender. Engoron dismissed the idea that the Attorney General's case was irrelevant and gave Trump 14 days to hand over specific documents, with all 3 Trumps having 21 days to be deposed. They filed an appeal on February 28th. On March 3, 2022, a compromise was reached where Donald Trump agreed to provide documents by March 31st without having the Trumps testify during the ongoing appeal. However, on March 28, James pushed for the Trumps' testimonies, highlighting discrepancies in financial statements, such as a property being valued 66 times higher than its external appraisal. The state appellate court backed Engoron's initial decision on May 26, saying a criminal investigation doesn't halt civil fact-finding. According to a previous agreement, the Trumps were scheduled to give their depositions in mid-July, but tried to appeal again, which was dismissed on June 14 due to lack of a significant constitutional issue. On another front, Engoron ordered a forensics firm working for the Trumps to share its findings by April 22 and allowed the Trump Organization to respond to another subpoena by April 29. He also addressed issues with Cushman and Wakefield, a real estate firm that used to appraise Trump properties, for not fully cooperating with subpoenas. Despite the firm's appeal and concern over client privacy, the court ruled against them, ordering the firm to provide the requested information. Faced with a $10,000 daily fine for non-compliance starting July 7th, Cushman and Wakefield eventually turned over more than 35,000 documents by August 5th, at which point the Attorney General's office requested to end the contempt order against them. Throughout these developments, numerous court decisions affirmed the need for transparency and compliance with legal inquiries, emphasizing the separate but parallel tracks of criminal and civil investigations. On April 7, 2022, New York Attorney General Letitia James requested that Donald Trump be held in civil contempt by a court for failing to comply with a subpoena for documents by a March 31st deadline. Trump's lawyers had raised objections, arguing that the requested documents were under the organization's control, not Trump's. On April 19th, Trump maintained in a court filing that he did not possess the documents in question. Subsequently, on April 25th, Judge Arthur Engoron found Trump in contempt, imposing a penalty of $10,000 for each day the compliance failed. A few days later, on April 29th, after Trump submitted an affidavit denying he had the documents, Engoron demanded a more detailed affidavit specifying the documents' possible locations to lift the contempt order. By May 2nd, 2022, Trump's legal team sought to pause the contempt ruling through an appeal, which was quickly denied the following day. On May 6th, in an effort to prove thoroughness, Trump's team submitted a detailed 66-page report on their search efforts and an affidavit from Trump stating he had no unproduced relevant documents, mentioning that 4 of his cell phones were missing. On May 11th, Engoron outlined conditions under which Trump's contempt could be cleared, including a $110,000 fine and a detailed third-party search for the subpoenaed documents. By May 20th, 2 of these conditions were met, and affidavits were submitted by Trump's staff, although 12 former executive assistants couldn't be reached. On May 31st, in a move that seemed to challenge Trump's earlier claims, Engoron's longtime executive assistant revealed that the organization lacked a document retention policy. By June 1st, both sides agreed to provide a report by June 3rd about efforts to contact former assistants and an affidavit from another assistant related to a pro-Trump political action committee. On June 8th, Engoron stated Trump would stay in contempt unless his organization offered explanations by June 17th about the handling of his handwritten instructions. An employee commented to Business Insider on June 19th that such documents were usually discarded. Finally, on June 29th, after meeting certain conditions and with the $110,000 fine paid into an escrow account, Engoron lifted the contempt order against Trump. On February 14th, an appeals court upheld this fine, affirming the decision. On April 25, 2022, a top lawyer from the Office of the Attorney General made it clear that their investigation was almost finished. They mentioned that the time limit to bring a lawsuit concerning some alleged wrongdoings was about to run out on April 30th, having been previously extended to go through important documents. By June 2nd, the Attorney General, Letitia James, highlighted solid proof that Donald Trump had given false values for his assets. She mentioned that one of the outcomes they could seek from suing was possibly shutting down his organization. They could use New York's tough anti-fraud laws for this, laws like the Martin Act and Executive Law, Section 63, subsection 12. These laws have been used by the Office of the Attorney General before, including against 2 of Trump's businesses. In a separate event in July 2022, a lawsuit was filed by a black ex-employee against Trump's lawyer, Alina Habba. The lawsuit accused her of racial discrimination, pointing out an instance when she yelled a hateful comment about the Attorney General. It also highlighted Habba's use of racial slurs, including her use of a deeply offensive word while singing along with a colleague, for which audio evidence was claimed to exist. When confronted, Habba reportedly defended herself by saying she was also a minority and questioned why she couldn't listen to Kanye West like everyone else. The deaths of Ivana Trump in July paused the depositions of her children, Donald Jr. and Ivanka, until the end of that month and the start of August. Donald Jr. cooperated fully, admitting his limited accounting knowledge and stating he had played no significant role in preparing the company's financial statements since 2010. He did mention signing some financial documents based on the advice of professionals. Donald Sr., during his deposition on August 10th, chose to invoke the Fifth Amendment over 400 times, only breaking his silence to criticize the Attorney General and her investigation. There was a request for his deposition to be moved to Trump Tower for what was claimed to be security reasons by his lawyers, a claim later countered by the Secret Service in September. Also in September, the Office of the Attorney General turned down a settlement proposal from Trump's organization. On September 21, 2022, during a news conference, James revealed that she is taking legal action against Donald Trump, his 3 eldest children, and their company, accusing them of fraud and deception with over 200 cited incidents. She highlighted that Trump grossly overestimated his wealth by billions, underlining the serious allegations against him and his company. James pointed to a specific New York law that grants her the authority to pursue such case, indicating she is standing on solid legal ground. The lawsuit details 7 specific illegal actions. 1. Consistent and repeated deception through false statements or withholding of information. 2. False documentation or failing to record true entries in business records with the goal of committing or concealing other crimes. 3. A plotted effort to fake business records in accordance with state law. 4. Providing misleading documents relating to Trump's financial situation. 5. A scheme to issue untrue financial statements. 6. Submitting insurance applications with knowingly false information and hiding crucial facts. 7. A plotted effort to commit insurance fraud. The court filing accuses Trump and his company of inflating asset values on financial statements between 2011 and 2021, misleading financial institutions to gain unfair financial advantages, and dodging $85 to $150 million in interest payments to Deutsche Bank. The lawsuit seeks roughly $250 million in damages and proposes significant operational bans against the Trump Organization and personal bans against Trump and his eldest children in New York business sectors. James' lawsuit suggests Trump inflated the worth of several properties, including his Manhattan penthouse, 40 Wall Street, and Mar-a-Lago, and misrepresented other assets' values, showing a pattern of alleged financial manipulation. She also reported potential criminal insurance and bank fraud activities to federal authorities and the Internal Revenue Service for further investigation. When the lawsuit was announced, Trump responded in a Fox News interview with Sean Hannity, claiming that disclaimers on his organization's financial statements, issued by the accounting firm Mazars, should clear him of the fraud charges, as they acknowledge the asset valuations might not be accurate. In a continuation of the lawsuit's procedural aspects, on October 13, 2022, after some difficulty serving Donald and Eric Trump with the lawsuit, the Attorney General's office obtained permission from Judge Engoron to serve them electronically, which was done promptly, showcasing the legal efforts to ensure the Trumps were formally notified of the charges against them. On the day they initiated their lawsuit, the Trump Organization proceeded to establish a new entity named Trump Organization 2 in Delaware, according to records with the New York Secretary of State. The New York Attorney General accused the Trump Organization of continuing fraudulent activities even after the lawsuit commenced, suggesting they might be reorganizing their business. They requested that Judge Engoron order Donald Trump to transparently elucidate how valuations are derived to an independent monitor, particularly in transactions involving lenders or insurers, and sought to schedule a trial date for the following year. In response to these allegations, Trump's lawyer, Haba, affirmed in writing the Trump Organization's commitment to proper conduct. An administrative judge, on October 25, 2022, declined to transfer the case to another judge. The subsequent day, the Trump Organization requested the dismissal of the New York Attorney General's plea for an independent monitor. Haba criticized this request as an overstepping of boundaries. In an action on November 2, 2022, Trump filed a counter-lawsuit in Florida through his lawyer Boris Epstein, aiming to prevent Attorney General James from accessing records of his trust, alleging this action violated Florida's constitutional privacy protections. The Attorney General challenged this lawsuit as a strategy to conceal the Trump business empire's structure. This Florida lawsuit was moved to federal court later that month and was eventually dismissed by federal judge Donald Middlebrook on December 21, noting Trump withdrew the lawsuit on January 20, 2023. Regarding the assignment of an independent monitor, Judge Engoron, on November 3, 2022, identified consistent inaccuracies in Trump's financial statements from 2011 to 2021 and indicated the Attorney General's lawsuit had a strong likelihood of success. To prevent further fraud or illegal activities, Engoron decided on installing an independent monitor over the Trump Organization. This monitor would supervise operations to ensure no assets are inappropriately sold or transferred out of reach, and required Trump to notify the court 14 days prior to any non-cash asset transfers from his 2021 financial statement. Trump's defense, arguing that accountants' disclaimers absolve him from liability, was rejected by Engoron. Both the New York Attorney General and the Trump Organization were directed to nominate 3 candidates for the monitor role by November 10th, with retired Judge Barbara S. Jones being the ultimate selection, officially commencing her duties in December. Meanwhile, the appeal against the monitor's installation was submitted by the organization's lawyers on November 7th, labeling it a restriction on their business operations. They sought a halt on the order while the appeal was under consideration, which was declined. Lastly, by December 5th, Ivanka Trump was removed from the monitoring requirement since she had departed from the company. On November 21, 2022, the legal team representing the Trump family and their organization asked a judge to dismiss a lawsuit against them. The very next day, the judge, named Engoron, turned down the organization's plea to postpone the trial for more than a year, setting a provisional trial date for October 2, 2023 instead. By January 6, 2023, Engoron decided not to dismiss the lawsuit, labeling the request as frivolous because it reused arguments that had already been denied. Despite this, he chose not to penalize Trump's attorneys. He dismissed claims that some of the alleged illegal activities were too old to be considered under the statute of limitations and also refused to drop the charges against Ivanka Trump. Following this, the Trump's lawyers decided to appeal the decision. On January 26, 2023, Trump's legal team contested the lawsuit's definitions of the Trump Organization and defendant. They argued that the lawsuit improperly linked the two, suggesting that for legal purposes, the Trump Organization as named doesn't exist. The lawsuit doesn't specifically name Trump Organization as a defendant, but does list 10 of its entities, including the Trump Organization, Inc., and names Donald Trump, his 3 oldest children, Alan Weisselberg and Jeffrey McConney, a longtime senior vice president and controller of the company, as defendants. Then, on January 31, 2023, the Office of the Attorney General asked for a pre-trial conference to consider penalizing the Trumps because of some defenses they had given. The Office of the Attorney General pointed out these defenses were demonstrably false due to their contradictory statement, reuse of dismissed arguments, or failure to counter the accusations made against them or their company. A hearing on this matter happened on February 1st, which Trump's lawyer Haba missed. During this hearing, Trump's lawyers opposed the sanctions and disputed how the organization's name was used in the lawsuit. Meanwhile, the Attorney General's Senior Enforcement Counsel highlighted that in their January 26 filing, the defendants did not acknowledge that Trump had remained the actual president of the company while he was also serving as U.S. president, despite him saying so under oath in a different lawsuit. The judge confirmed that the trial would proceed as planned on October 2nd. In mid-February 2023, Donald Trump's legal team issued subpoenas to key figures including Rosemary Vrablic, Trump's longtime private banker from Deutsche Bank, and Donald Bender, a Mazars accountant who worked with Trump's organization. Towards the end of February, they also subpoenaed Michael Cohen, Trump's former lawyer, and there was talk of attempting to take further depositions from Donald and Eric Trump by the Attorney General's office. Despite the judge setting a firm date for the trial to commence, Trump's attorneys requested an additional 6 months on March 3, 2023, to sift through a massive load of 275,000 documents. They estimated that reviewing these documents would take about 11,000 hours and argued they needed more time for preparation and to issue subpoenas. The Attorney General's office, however, pointed out that many of the documents were from Trump's own records, implying his team should already be familiar with them. In a similar vein, Ivanka Trump's legal team sought more time to build her defense, citing her unique situation and her claim of not being involved in the allegedly fraudulent activities. On March 15th, the Attorney General urged the judge to reject Trump's request for a delay to avoid interference with his 2024 campaign activities. Subsequently, on March 21st, Judge Engoron stated that the trial date was written in stone, allowing only slight extensions for evidence gathering. During a 7-hour deposition on April 13th, Donald Trump echoed his previous assertions from 2022 regarding the organization's financial statements to banks and his repayment of loans, even during his presidency. He also distanced himself from the company's current operations, highlighting his son Eric's primary role. Trump's lawyers made his deposition public on August 30th. The legal representation for Ivanka Trump saw changes in April, with her previous attorneys stepping down and a new solo attorney taking over her case by April 21st. Complications arose with the document discovery process, especially concerning Ivanka's emails between 2014 and 2017, leading to the court setting strict deadlines for document submission and compliance, with a specific focus on avoiding perjury charges. Michael Cohen was deposed on April 28 by Trump's lawyers. A significant legal development occurred on June 27 when an appellate court ruled that the case could proceed, but limited the scope of charges based on statutes of limitations, which notably led to Ivanka Trump being potentially dismissed from the case due to her no longer being associated with the implicated transactions by the time of an August 2021 agreement between the OAG and Trump's organization. Finally, on July 31, 2023, the Attorney General announced the completion of trial preparations, emphasizing the right to address any evidence destruction by the defendants after the trial concludes. On August 30, 2023, the Attorney General made a request to the judge for a summary judgment in a lawsuit alleging that Donald Trump, along with his organization, grossly overstated his wealth and asset values from 2011 to 2021, possibly inflating his net worth by $812 million, $2.2 billion, which is an increase of 17 to 39%. Trump's legal team countered by asking the court to throw out the case, arguing that their financial statements weren't misleading, and even shared a transcript of Trump's deposition from April 2023. On the same day, they attempted to pause the case until a decision on their summary judgment request was made. However, on September 5th, the judge shot down this attempt, finding it totally baseless. On September 5, 2023, the Office of the Attorney General suggested that the judge should penalize Trump's attorneys $20,000 for recycling what they called baseless arguments. By September 8th, the judge had decided the case would proceed without a jury, expecting it to run from October 2nd to December 22nd, 2023. Trump's legal team didn't back down. On September 14th, they sought help from appellate judge David Friedman, claiming that Judge Engoron and the Attorney General were ignoring appellate court orders. One point of contention was that the judge hadn't yet decided whether some of the Trump organization's past actions were too old to be considered for fraud. Nevertheless, their request for a delay was denied by an appellate court on September 28th, and on October 5th, Trump's defense decided to permanently abandon their delay request. In an intriguing twist, the Daily Beast reported on September 15th that the Office of the Attorney General intended to call up to 57 witnesses during the trial, including employees from Deutsche Bank, Zurich Insurance Group, and Cushman & Wakefield. Final witness lists submitted by the end of September showed that both the prosecution and defense could call a mix of 155 individuals, including Donald Trump himself and his sons, Donald Jr. and Eric Trump. It's worth mentioning that in civil cases like this one, defendants might have to take the stand, and opting not to do so could work against them. Further developments on September 22nd saw Trump's attorney Chris Kise pushing for dismissal once more, claiming that no harm came from his client's actions. Yet Judge Engoron held firm, highlighting the significance of fairness in the marketplace. In his ruling, he echoed past judgments that emphasized a state's interest in preserving market integrity. On October 4th, Trump's representatives didn't let up and appealed against the refusal to dismiss the case, continuing the legal saga. On September 26, 2023, Judge Engoron made a significant ruling. He found that except for Ivanka Trump, the defendants had consistently engaged in fraudulent activities for years. They did this by inflating Donald Trump's net worth and the value of assets on financial documents. These overstatements were used in negotiations and to obtain loans. Despite Trump's argument that disclaimers on these statements meant they couldn't be taken as absolute truth, the judge didn't accept this reasoning. As a repercussion, he ordered that the business licenses of the Trump Organization in New York be revoked. This decision could lead to the dissolution of several Trump-related limited liability companies, and the defendants have 30 days to suggest who might oversee this process. The judge highlighted some glaring examples of this fraud, like tripling the size and value of Trump's Trump Tower apartment and valuing Mar-a-Lago way beyond its actual worth, even suggesting it could be 22 times overvalued. On the same day, Judge Engoron also fined 5 of Trump's defense lawyers $7,500 each. He did this because they kept using arguments that had already been dismissed repeatedly by both the Supreme Court of New York and its appellate division. According to the judge, the defense was living in a fantasy world with illogical comparisons, such as claiming rent-controlled apartments should be priced the same as unregulated ones. He strongly criticized Trump's defenses as baseless and detached from reality. Moving into October, on the 5th, Judge Engoron required Trump to list entities he controls or has a significant interest in. Both parties in the case were given 30 days to suggest a suitable receiver, with an expectation they might both propose Barbara S. Jones for the role. Following these events, Trump's legal team appealed the summary judgment and sought to pause it along with the upcoming trial. However, on October 6, an appeals court judge refused to halt trial. Yet, it paused the action to dissolve Trump's New York business entities until after the appeal is reviewed. The trial commenced on October 2, 2023, and concluded on January 11, 2024. It was set to explore 6 allegations against James, including falsifying business records and insurance fraud. The court also contemplated imposing a $250 million penalty on Trump for his alleged wrongdoings and possibly banning him and his associate from dealing in New York real estate 5 years. Right from the start, on October 2nd, the tone was established for a drama-filled trial, largely because it proceeded without a jury, a decision made despite Trump's lawyer, Alina Habba, claiming Trump had wanted one. Judge Engoron, who was overseeing the trial, mentioned that a jury wasn't an option given the nature of the penalties sought. Trump's attendance was partial. He appeared for the initial couple of days and made headlines with his remarks against Judge Engoron, whom he called a rogue judge and accused of political bias. Adding to the controversy, Trump targeted Engoron's law clerk on social media, which led the judge to issue a gag order to prevent further public comments about his staff. The initial days featured testimony from Donald Bender, Trump's longtime accountant, and Jeff McConney, a former financial controller at Trump's organization, discussing the valuation methods used for various Trump properties. In the trial's second week, notable moments included the revelation of a 1994 document signed by Trump, which contradicted the inflated size of his Trump Tower penthouse reported in financial documents years later. Alan Weisselberg, another key figure, admitted to overlooking significant overvaluations of property, despite evidence suggesting otherwise. Testimonies from a Deutsche Bank officer highlighted how Trump's financial exaggerations helped him secure more favorable loan terms. An interesting detail was the revaluation of Trump Tower's worth after a Forbes article debunked Trump's claims about his penthouse size. Moreover, discussions around a presidential premium to inflate asset values further illuminated the intricate methods by which valuations were manipulated, though these inflated figures were not used in official financial statements. Michael Cohen was all set to give his testimony for at least 2 days during the week starting October 16, 2023. However, on October 13th, he shared that due to a medical condition he was dealing with, he would have to postpone. Later, he let everyone know he would be ready to testify the following week, starting October 23rd. On the first day of that week, a key moment came when Bernie revealed that at some point between 2017 and 2019, Weisselberg confided in him about Trump wanting his financial statements to show an increased net worth. Trump's lawyers quickly countered, describing this testimony as hearsay. The same day, Trump, who hasn't shied away from criticizing the Attorney General, shared a link to a story by Laura Loomer, a known far-right activist, which alarmingly included the Attorney General's home address. It's important to note the court's order to keep quiet applies to its staff, not to others connected to the trial. By October 17th, Trump showed up at the trial again and mentioned to reporters that he believes Mar-a-Lago is worth a huge amount, estimating between $750 million and $1.5 billion. The next day, Trump was there for part of the day. During this time, organization executive Doug Larson was cross-examined, and he expressed his surprise over documents indicating he had advised on valuations, something he denied. However, emails from 2013 were brought up showing his involvement despite his previous contradiction. After his defense lawyer suggested he might want to consult his own lawyer, possibly to consider his rights against self-incrimination, Larson stated he didn't recall advising on these valuations, even though the emails suggested otherwise. On October 19th, the Attorney General highlighted a Forbes article from the previous week, suggesting that subpoenaed evidence had been withheld, evidence that was later provided by Marcus and Millichap. The Attorney General proposed that an independent monitor should review the organization's records from August to September 2016. That same day, we heard from Jack Weisselberg, who mentioned that in securing a $160 million loan for the organization, Trump's financial statements were a significant factor, especially the claimed value of Trump's liquid assets and his net worth. David McArdle, a Cushman & Wakefield executive, also testified on October 19th. He talked about his appraisal work on undeveloped units and conservation easements at Trump National Golf Club, Westchester. The figures he provided for these appraisals were significantly lower than the values claimed by the organization, with the Attorney General pointing out discrepancies and suggesting verbal instructions from Eric Trump might have influenced these higher claimed values. Ivanka Trump, on the evening of October 19th, requested the court to dismiss her subpoena, arguing the subpoenas were improperly served to business addresses and not to her personal residence, and noting she doesn't live in New York anymore. On October 20th, a fine of $5,000 was imposed on Donald Trump by Engoron for not complying with a gag order. Engoron mentioned a specific instance from October 3rd, when Trump was asked to remove a disparaging online post about a court staffer, which he reportedly did, only for it to be found on another site 17 days later, removed only after the court intervened. Engoron termed this a blatant violation, warning of more severe consequences for any further violations. On October 24, 2023, Michael Cohen shared his testimony with both Donald Trump in attendance. He revealed that Trump had instructed him to bump up his asset values to a figure Trump himself just picked out of the air. Cohen described how they would work backward from this arbitrary number to make the financial statements match, a process assisted by Alan Weisselberg. Weisselberg even brought the 3 oldest Trump children into the fold for this task. Moving on to October 25th, during Cohen's questioning, there was a moment when Haba voiced frustrations to the judge about distractions like eye rolls and whispering in the courtroom, leading to the judge taking steps to prevent further disruption. Amidst a break, Trump was caught telling reporters that he felt the judge and his clerk were biased against him, a statement that the judge found to be a breach of a previous warning not to speak out, resulting in a $10,000 fine for Trump and a stern reminder to not repeat such actions to avoid harsher consequences. Cohen, under further examination, acknowledged that Trump never explicitly instructed him to fudge the numbers on his personal financial statements. Trump's lawyers jumped at this admission, attempting to have the case thrown out, but the judge wasn't swayed, pointing out that despite Trump's interpretation of Cohen's statement as a win, Cohen hinted at a subtler form of instruction from Trump, likening his communication style to that of a mob boss who implies his desires without outright saying them. Despite these arguments and another push to dismiss the case, citing Cohen's credibility issues, the judge decided the evidence was too substantial and kept the case alive. On another front, on October 27th, the spotlight turned to Ivanka Trump when the judge ordered her testimony, highlighting her significant connections to New York through her business activities and real estate dealings. This decision underscored Ivanka's deep involvement with the organization, noting its contribution to her expenses and its undervaluation of her apartment, further entwining her in the ongoing legal proceedings. On November 1st, Donald Trump Jr. shared during his testimony that he didn't play any part in creating his father's financial statements, stating these were handled by the company's accountants, particularly mentioning the 2017 statement. He also mentioned his lack of memory regarding certain specifics, such as why he was re-added in 2021 to a revocable trust in his father's name after a brief period of resignation, and whether his father, Donald Sr., remained a trustee. Donald Jr. continued his testimony on November 2nd, noting his limited recollection of agreeing to a $2 million severance deal with Weisselberg and emphasizing his trust in Weisselberg and the Mazars accounting firm for their work on financial documentation. Despite not remembering a 2017 email he sent regarding his father's Trump Tower penthouse that mentioned an insane amount of stuff there, a week later he endorsed a financial statement that exaggerated the penthouse's size and value. He defended the accuracy of these statements in court by citing his reliance on the accountants. Eric Trump, testifying also on November 2nd, echoed his brother, affirming his detachment from the preparation of the financial statements in question. He faced queries about a 2012 email conversation concerning a possible acquisition of a golf course and a financial statement that outlined Donald Trump's net worth. Though initially unsure if this document was a financial condition statement, evidence later demonstrated his involvement in reviewing appraisals for a Westchester property, slightly contradicting his previous statements of minimal involvement. On the same day, Ivanka Trump's legal team sought to pause her upcoming testimony and the trial itself, citing concern over disruptions during her children's school week, arguing it posed undue hardship. However, their request was swiftly denied by a higher court, prompting them to retract their appeal the following day. Further drama unfolded on November 3rd when Judge Engoron extended a gag order to Trump's legal representatives, motivated by specific comments and growing threats against his team. November 6th marked Donald Trump's last appearance in court, where he testified for 4 hours, often responding to questions with lengthy comments, leading the judge to remind him that the court was not a political platform. Trump reiterated his belief that disclaimers excused any inaccuracies in his company's financial statements, admitted to reviewing these documents and occasionally suggesting modifications. He conceded that the valuation of his Trump Tower penthouse and other properties might have been inaccurately reported, noting this as an error by his organization. Upon exiting the court, he maintained that his actions were entirely correct. Ivanka Trump took the stand on November 8th, with the Attorney General noting her significant involvement in securing beneficial loans for the primary defendants and benefiting from misleading financial statements. Despite being presented with her emails, Ivanka struggled to recall many details, including her efforts to obtain $50 million from Deutsche Bank in 2016 for the Trump International Hotel in Washington, D.C. After hearing from 25 witnesses, the Office of the Attorney General concluded its case presentation. The defense began presenting their case on November 13th, with Don Jr. testifying as a character witness for the Trump Organization. The defense's presentations were expected to continue until December 15th, with Trump's team having spent over $2.5 million on expert witnesses. In the 7th week of the trial, on November 15th, the defense called for a mistrial, claiming that the judge was showing bias, a claim the Office of the Attorney General countered by saying it was without basis. The following day, an appellate judge put a temporary hold on the gag order, allowing time for a fuller panel of judges to review the matter in a hearing set for November 27th. Shortly after this pause, Jason Miller, a Trump aide, shared a link to a website attacking the court clerk. Trump then made disparaging remarks about her and Judge Engoron on his Truth Social account. By the 8th week, on November 20th, witness Jeff McConney testified about the origins of a disclaimer paragraph in Trump's 2015 financial statement, attributed to the accounting firm Mazars. During his cross-examination on November 21st, a handwritten note by McConney, replicating the disclaimer and highlighting the global value of the Trump brand, was shown. McConney also admitted to a note on a 2014 draft financial statement, which the Office of the Attorney General claims was overvalued by $3.5 billion, signaling Trump's review and approval. McConney expressed pride in his work despite resigning due to the organization's legal challenges, and noted that Eric Trump took over approval duties from 2017. Following Trump's critical posts, the court clerk became the target of over 50 harassing contacts daily, leading to a plea on November 22nd by Engoron's attorney, Lisa Evans, to reapply the gag order for protection. In the trial's 9th week, on November 29th, Barbara Jones, an independent monitor, reported to Judge Engoron that in 2023, the Trump Organization moved $29 million to Donald Trump for tax payments without reporting these transfers as required. On the same day, despite Trump's accusation against Engoron's wife of bias and controlling the trial, a banker's testimony highlighted the financial benefits Deutsche Bank received from its dealings with the defendants, undermining an attempt by Trump's lawyer, Chris Keiss, to prematurely end the trial. The next day, the gag order was reinstated by the appeals court, with Engoron committing to its strict enforcement, though Trump persisted in making public comments about Engoron's wife. Engoron also indicated that a decision on the trial would not come before the end of January 2024. On December 4th, Trump's legal team made a move to seek permission for appealing against the reinstatement of a gag order. This was met with opposition by the Office of the Attorney General on December 10th, urging the appellate division to dismiss their request. In an unexpected turn, Eric Trump's scheduled testimony for December 6th was called off. The following day during the trial, Donald Trump was present to hear testimony from Eli Bartoff, an accounting expert, who firmly stated there is no evidence whatsoever for any accounting fraud, and confidently asserted that the financial statements he evaluated were not significantly mistaken. Bartov even addressed the issue of the inflated valuation of Trump's Manhattan penthouse by noting, "Errors like that are not unusual." He disclosed on December 8 that his testimony came with a price tag of nearly $900,000, paid by the organization and the Save America Political Action Committee. Meanwhile, another defense expert witness received a similar financial compensation, in stark contrast to a state's expert witness who, despite charging a comparable hourly rate, earned $350,000. Additionally, on December 7th, a positive development for Trump emerged when a New York appeals court decided to delay the annulment of Trump's business certificates until the trial's conclusion and the processing of related appeals. Jumping ahead to Week 11, Donald Trump, who had previously provided testimony on November 6th, was slated to testify again on December 11th. However, he withdrew the night before, announcing via Truth Social his decision, which was based on his belief that there wasn't anything new to add, except to reiterate his claims of election interference allegedly by Joe Biden's campaign. Trump further expressed his frustration on December 12th regarding the gag order, arguing it infringed on his constitutional right to defend himself. Regardless, the defense concluded their presentation that day. December 13th witnessed the testimonies of an in-house real estate broker who highlighted an evident exaggeration in the square footage of Trump's property, a figure given by Alan Weisselberg, and an accounting professor who provided counter-arguments to those presented by an expert on Trump's behalf. On December 14th, Trump's attempt to overturn the gag order was rebuffed by the New York Appellate Division, characterizing the gag order as narrow and hence minimizing the gravity of potential harm. This appeal was eventually dismissed the next month. Mid-December updates revealed Trump's lawyers' intentions to challenge future unfavorable rulings, which led to a notably sardonic response from Judge Engoron. After the final week of testimony, a month-long break was expected before resuming in-person hearings. On December 18, 2023, Judge Engoron addressed Trump's legal team's request for a directed verdict, critiquing it for presuming that their expert witnesses' testimonies would be deemed wholly credible. Specifically, the judge questioned Eli Bartov's integrity, considering his portrayal of the financial statements as impeccable despite prior judicial findings of numerous obvious errors. Engoron also dismissed the defense's argument on the subjective nature of valuation, summarizing that misinformation remains unacceptable. Trump's lawyer Chris Kise criticized this as a dismissal of tangible facts. Furthermore, Judge Engoron clarified that financial disclaimers could not absolve the defendants of liability, but rather implicated them further. Looking ahead, January 5, 2024 was determined as the deadline for both parties to submit their written arguments. On this date, the Office of the Attorney General, represented by James, proposed barring Trump from engaging in real estate business in New York and raised the stakes by increasing the demand for disgorgement $370 million. Just before the closing arguments were set to begin, Trump showed an interest in personally approaching the stand during his defense team's final presentation. On January 10, 2024, Judge Engoron opened the opportunity for Trump to discuss facts and laws relevant to the case that were already introduced as evidence, making it clear he couldn't introduce new evidence, deviate into irrelevant topics, or transform the occasion into a political rally. However, after pushback from Trump's legal team regarding these conditions, Engoron decided Trump could not deliver the closing arguments after all. Adding to the tension, on the same day, Trump expressed his frustration on social media, calling Engoron a Trump-hating judge and accusing him of unfair practices. The following morning, January 11th, as the closing arguments were poised to begin, a distressing swatting threat targeted Engoron's home. Thankfully, it turned out to be a false alarm, with no bomb discovered. Trump, making his 9th appearance in court for the trial, took a brief opportunity to speak, reaffirming his innocence and suggesting he was being persecuted for political reasons. Engoron allowed him approximately 6 minutes before interrupting him. In a new strategy, one of Trump's attorneys argued that the penalties being sought were unconstitutional. Another notable defense moment occurred when Haba, highlighting the Attorney General's casual demeanor in court, observed with a Starbucks coffee and barefoot, suggested the entire case was driven by a particular agenda. The judge dismissed these observations as irrelevant, but allowed Haba's argument to continue. On January 23rd, the Attorney General's office cited a recent legal decision that permanently banned Martin Shkreli from the pharmaceutical industry, bolstering their case for a similar lifetime prohibition against Trump in New York real estate. By January 26th, Barbara Jones, who had been overseeing Trump's organization for 14 months, recognized their cooperation but pointed out problems with the timeliness, completeness, and accuracy of documents provided, including the denial of a $48 million loan Trump claimed he owed to his company, a point that has spurred allegations of tax evasion. A lawyer for Trump responded, arguing that the issues Jones highlighted were minor and accused her of exaggerating her findings to justify her fees, which reportedly exceeded $2.6 million. In early February, Judge Engoron inquired about details regarding Alan Weisselberg's plea agreement in a criminal case, considering the potential for perjury in Weisselberg's civil case testimony and its implications for his ruling. Weisselberg later confessed to perjury following Engoron's decision. Initially scheduled for late January, Engoron's verdict was then expected by mid-February. On February 16, 2024, Judge Engoron made observations regarding a case where the defendants, aiming to obtain loans under more favorable conditions, provided their accountants with completely inaccurate financial data. This resulted in financial statements that weren't truthful. During the trial, it became apparent that the testimony from the defendants' side, including both their factual and expert witnesses, evaded facing the truth. There was a clear refusal by the defendants to admit their mistakes or to take measures to prevent such actions from recurring in the future. Judge Engoron remarked that the defendants seemed incapable of recognizing their wrongdoings, highlighting that their absence of regret or remorse was almost extreme. Judge Engoron also addressed and rejected various defenses presented. Contrary to the defense's assertions, lenders indeed depended on these incorrect financial statements when approving loans. When the defense attempted to attribute blame to the accounting firms hired by the Trump organization, Judge Engoron pointed out substantial evidence from the trial showing that these firms relied on the Trump organization to supply accurate information and had every right to expect honesty. Additionally, when the defense contended that differences in financial assessments were common and not indicative of fraud, Engoron made clear that genuine appraisal science cannot inherently involve deceit. In his perspective, when two appraisals are grounded on fundamentally different assumptions, it signifies not just a variety of opinions, but suggests intentional deception. On February 16th, Judge Engoron made a decision that Donald Trump and his business entities must pay back $354.8 million. This sum is what they're believed to have gained through unethical means, and it breaks down as follows. $168 million is essentially the amount saved from getting loans under more favorable terms thanks to providing misleading financial statements. $126 million came from profits after selling the old post office, a deal also sweetened by those misleading financial statements. $60 million was earned from the sale of the Ferry Point golf course in New York. On top of that, Donald Trump's eldest sons, Donald Jr. and Eric, are required to each pay $4 million from the profits made on the old post office deal. Alan Weisselberg, closely associated with the Trump organization, has been told to cough up $1 million from his exit compensation. Together, all defendants are on the hook for a total of $364 million. Judge Engoron added that Donald Trump must also pay interest on this amount. By February 23rd, the judgment was set in stone, including around $100 million that Trump owes just in interest. Although Trump mentioned in his deposition in April 2023 that he has substantially in excess of $400 million in cash and that his financial standing was going up very substantially, it's still up in the air whether he actually has enough liquid cash to settle this judgment. Come February 20th, James hinted at potentially asking a judge to take steps towards seizing Trump's assets if he can't pay up. This action could involve the New York City sheriff or implementing a judgment lien to ensure compliance. In his decision, Judge Engoron found that most of the defense's witnesses were either not relevant or didn't come across as trustworthy. He specifically mentioned Ivanka Trump, who, although no longer a defendant due to legal time limits, was called upon to testify. Engoron noted that Ivanka's testimony was clear, yet he found it odd how she struggled to recall key details about loan negotiations when the prosecution asked her questions. This was in contrast to her detailed memory during the defense's cross-examination. Turning to restrictions on business activities, Judge Engoron issued a significant ruling against Donald Trump, Alan Weisselberg, and Jeffrey McConney, banning them from leading any New York-based companies for 3 years. Eric Trump and Donald Trump Jr. were similarly banned, but for a duration of 2 years. Furthermore, Weisselberg and McConney were permanently barred from holding financial control positions in any New York company. While Engoron stopped short of dissolving the businesses involved, he did order an independent director of compliance to oversee the organization's financial reporting. He also instructed independent monitor Barbara Jones to continue her role for a minimum of 3 years. Regarding the timing of these legal actions, Trump's legal team reached out to Judge Engoron on February 21st and 22nd, seeking to postpone the enforcement of his ruling. However, Engoron denied this request, stating that Trump's lawyers hadn't provided a valid reason for the delay. He proceeded to finalize the judgment on February 23rd, which meant that Trump had 30 days to challenge the decision. To do so, Trump would need to either pay in cash or secure a bond for $454 million. Donald Trump was given a deadline to provide a financial guarantee, known as a security or bond, which included an annual interest rate of 9% to support his appeal. This guarantee was necessary to prevent the collection of a judgment against him while his appeal was ongoing. Trump requested to delay this financial requirement on February 28th, explaining through his legal team that it was not feasible to secure the full bond amount of $464 million, though he could manage $100 million. Appeals Judge Anil Singh denied the lower bond request but did agree to delay certain restrictions on Trump and his co-defendants, such as banning them from taking out loans or holding officer positions in New York companies. Fast forward to March, the New York Attorney General's office took action that hinted at the possibility of seizing Trump's properties, including his Westchester Golf Club and the Seven Springs estate. The Attorney General's office argued that Trump had not demonstrated the impossibility of fulfilling the full bond without selling assets and had not proved his liquid assets were insufficient for covering the judgment post-appeal. Furthermore, it was pointed out that Trump's team had unsuccessfully attempted to relocate the organization's major entities, Florida, which raised concerns. By March 18th, in response to an appeal deadline, Trump's lawyers contended that obtaining the required bond was essentially impossible after multiple companies refused to support it. Despite this, the Attorney General's office insisted on the full bond amount, suggesting it could be divided among different guarantors. Throughout this process, Trump leveraged the legal case for political fundraising, claiming he possessed nearly $500 million in cash earmarked for political activities. He argued that this cash was being targeted by the court unjustly, while also noting potential profits from a business merger that might yield billions. On March 25th, the deadline for the bond, a group of judges allowed Trump an extension and reduced the bond amount to $175 million. This reprieve also lifted certain bans on Trump and associates, but kept in place the order for an independent monitor for his business operations. Trump secured this reduced bond amount through Knight Specialty Insurance Company and its parent company, with the cash collateral held by Charles Schwab Corporation. By early April, concerns were raised about the insurance company not being recognized in New York, and questions about the cash collateral's use. The Attorney General pressed for a new bond due to these issues and the insurance company's limited capacity to cover the full bond value. However, on April 22nd, a ruling allowed the existing bond to stand, with stipulations ensuring the cash was reserved solely for the bond's purpose. On February 26, 2024, Donald Trump, along with his adult sons and 2 past officials from the Trump Organization, took their case to the higher court in New York, specifically the Supreme Court Appellate Division. Trump's legal team raised questions about whether the judge, Engoron, made legal or factual errors and if he overstepped his bounds in his jurisdiction. Even though the appeal wasn't expected to be discussed until at least September 2024, Trump, during a campaign event on April 2nd, incorrectly announced that he had won the case because of what he referred to as a statute of limitations. He also called Engoron a rogue and fake judge, mistakenly saying that the judge was unaware of his supposed victory. Then, on April 22, 2024, Judge Engoron confirmed Trump's bond payment and dismissed the argument from New York Attorney General Letitia James that sought to invalidate Trump's claim. Thanks for watching. Share your thoughts in the comments and subscribe for more content.